first matter to come before the court this morning is State of Ohio versus Zachary H. Meyerson. Both sides will have 15 minutes to argue. If you're the appellant and you wish to reserve any time for a rebuttal, you may reserve up to 5 minutes. If you let me know when you get started, I'm the one in charge of the time clock. You also can keep track of that yourself. It helps me if I need to remind you that you're reaching any reserved rebuttal time. Please don't use the names of any victims or minors. I don't really know that that's all that relevant to this case, but we are recording, and this will be posted on the court's YouTube channel. Please also remain at the podium for those same purposes. The court has read the briefs, and we're ready to proceed when you are.
Yes, thank you, Judge. May it please the court, my name is William Norman. I represent the appellant Zachary Meyerson. I'd like to reserve 5 minutes of rebuttal time, please. Thank you, and may it please the court. Your Honor, I'd like to begin with the issue of defense counsel's concession of guilt in closing arguments over my client's express objections. Under McCoy v. Louisiana, it's quite clearly stated that the objective of representation belongs to the defendant alone to decide. That is to say, even if an attorney, in their experienced, learned wisdom, believes that it is better to concede guilt to avoid some worse fate, it is not for that attorney to decide. That is kind of the facial framework of this type of argument. My colleague on the other side argues two things in rebuttal to this argument. First, she argues that res judicata bars this claim because this concession was in the trial record. That is not complete, and the reason why is because my client's express objection is not in the trial record. Nor, of course, would it be. In any McCoy v. Louisiana claim, these are going to be privileged conversations between the defendant and their attorney. There will not be another outside bit of information. And so I would ask my colleague to identify where in the record my client's express objection to this concession of guilt lies.
Am I correct in recalling that there is a statement on the record your client indicated he did not want to testify?
Yes, Your Honor. And that is a separate matter, and frankly, I would concede that argument.
I want to try and how would trial courts be left then to deal with trying to determine if parties were disingenuous in saying, I really wanted to testify, I put on the record, though, that I didn't want to testify, without having to have a hearing in every one of these cases to determine if that is or isn't a credible statement later?
Let me be clear, that is a separate point of argument, and I would concede that it was done on the record. I would concede that argument. The argument I'm dealing with here is that my client, to his attorney, in consultation, outside of the record, as shown by his affidavit, shows that he expressly objects his attorney conceding guilt. His attorney cannot then concede guilt. That's what McCoy v. Louisiana tells us.
Okay, I'm conceding he's not in the testifying, but
correct.
Guilt issue. Okay.
That's the issue I'm dealing with specifically.
Aren't matters of trial strategy in the lawyer's, is the lawyer's decision, not necessarily the defendant's decision? Like, to testify is the defendant's decision, no matter the recommendation of the lawyer. However, trial strategy is reserved for the lawyer. Is that correct?
Thank you for that question. It absolutely is. However, McCoy v. Louisiana hits on this exact point. What is a question of strategy, and what is a question of the objective of the representation? In McCoy v. Louisiana, it was a death penalty case, and his attorney believed that conceding the guilt of the murders was necessary in order to avoid the death penalty. And over his client's express objection, he conceded guilt. The court found, the Supreme Court of the United States, obviously binding, found that whether or not to concede guilt is not a question of trial strategy. Is not, cannot be. It belongs solely to the defendant. And so here, specifically speaking, first to, I mean, we're on the strategic question, but the res judicata was one of the issues raised. And yes, in the trial court record, of course, there is the concession. However, there is not any record of my client's express objection. And so if we had tried to raise it on direct appeal, my colleague would be saying, where is evidence of this express objection? And we can't add evidence at that moment. It is appropriate for post-conviction relief, and I would ask my colleague to identify in the record where we could have said in direct appeal, my client objected to that concession of guilt. It's nowhere in the record.
So you believe that your affidavit attached to your post-conviction petition is a sufficient outside of the record evidence that should warrant hearing?
Yes, I do, and to step back a moment, if this McCoy v. Louisiana has any heft at all, how else would we get that information? These are going to be privileged conversations between the attorney and the client, and the question of whether or not to concede guilt is probably, I mean, you'd probably even kick the mother out of the room to have that conversation. That is going to be privileged. So how could we possibly get that evidence in except for by affidavit? Now, the court doesn't have to necessarily accept it at the hearing. The attorney could come in and testify otherwise. Of course, the attorney may come in and say, well, I believed it was a strategic decision, and I believed it was so critical to the case that I decided to go this way. It was my error that I took that decision away from the defendant. He might do that. That's why we're asking for a hearing. We're not asking this court to vacate the conviction. We're asking for a hearing. And the hearing is the only way to resolve that McCoy v. Louisiana question. And
What other issues would you present at a hearing? If you were to be granted a hearing, what other issues would you present that are not raised judicata?
Well, certainly any issues that this court reverses and remands on. I would say specifically on McCoy v. Louisiana, I think that's our strongest one. Because the idea that the court can just wave it away by saying, oh, well, the concession was in the trial record. The concession is always going to be in the trial record. And the client's objection is never going to be in the trial record. Now, there's also a case before McCoy, Nixon. And Nixon is a case where the defendant said nothing. That the attorney testified that I told him I was going to concede guilt, and I got nothing back. And the Supreme Court said, well, look, if you haven't objected, then the lawyer's free to go forward. But if you have objected, then the trial counsel is bound by that decision, because it's an objective of representation, not a matter of strategy. So I think that takes care of the res judicata and the strategic decision question. And then my colleague says, essentially, whether it would have made a difference or not. I just can't take seriously the argument that a concession of guilt is not a weighty thing for a jury to consider. This is not a case where there's overwhelming evidence, and we'll get to that in just a little bit. This is a case where a statement was made to a therapist. That statement, allegedly from the minor victim here, was that a toy was shoved up his butt and was made to poop it out, right? The state's medical expert says there was no tearing, there was merely bruising, right? Now, so that's somewhat inconsistent, fine. Maybe you would say, well, that's maybe an inaccurate description by the child. But the child was never cross-examined, was never questioned at all. So then, okay, well, maybe we could question the doctor. But of course, the doctor was not available because she died. And so instead, her handwritten notes, which is entered into the record, read into the record by a detective, with no opportunity to question the credibility of this question. I only say that, and we'll get more to the res judicata questions that are wound up in this. I'm saying specifically for the McCoy v. Louisiana, that the idea that this concession of guilt did not matter because the evidence was so overwhelming, that's just not the case. This is not the case where you have the drugs in your pants pocket. This is a case that was highly contested.
But with regard to the part that was conceded, and that was just the assault, the assault part, not the rape part, did your client make a statement about that?
He did not testify.
He made a statement to the police.
He made a statement to the police. He did not make a statement that admitted to having injured the minors, hit him in the head, which was, I mean, he had like a fractured skull. The idea that, this wasn't some passing blow. He certainly did not admit to doing that, right? There were some admissions to the police. We've challenge those in other areas of the appeal. But suffice to say, he didn't testify to it. He expressly objected to his attorney having conceded that guilt. And the idea that a concession of guilt does not affect the jury in a way that would overcome, this error is, I think, not correct anyway. I'd like to move on now to the claims of ineffectiveness regarding not calling witnesses, specifically to my client gave information to his counsel and said the minor had a very bad fall in a parking lot a few days before this case, the incidents of this case when he went to the hospital and such. His mother had viewed him at that time, my client's mother, and found him to be lethargic, had a big bruise on his eye, and this was before the night when Mr. Meyerson was alleged to have been babysitting him and when this action would have taken place. The counsel did not investigate that, did not call the mother, and then Dr. Fadul, the expert that we brought on for post-conviction, opined that that certainly could have been the issue of a fall, could have been caused by a fall. Now my colleague says that Dr. Fadul could not have rendered an opinion because he's not sufficiently qualified.
And counsel, I just need to make you aware you're into your rebuttal time.
I'll be
Continue.
30 more seconds, thank you, Judge. The idea that based on this CV, he is automatically disqualified from being an expert, and that we couldn't have had a 702 hearing to determine whether he's an expert. In my experience, and I think that in anyone's experience, that the CV is a starting point. It is not the entire universe of experience that is considered to determine whether someone's qualified under 702. The CV is incomplete. It doesn't always get every single bit of job experience. For instance, Dr. Fadul was the team doctor for the Washington Nationals, certainly familiar with head injuries, certainly familiar with subdural hematomas. And so, Your Honor, we would say that the idea that merely because his his CV doesn't list that he's a pediatric neurologist, it doesn't mean that he couldn't have been qualified. I'll save the rest of my time for rebuttal. Thank you.
Thank you, counsel.
Good morning, and may it please the court. I'm Jacqueline Corgan on behalf of the state. And this court should affirm the trial court's decision on this post-conviction relief petition because all of Mr. Meyerson's post-conviction relief claims were either addressed by this court in his direct appeal, could have been addressed by this court in his direct appeal, or are meritless. So the trial court did not abuse its discretion when it denied Mr. Meyerson's post-conviction claim. And
I'm going to stop you there because do you think that a private conversation between his lawyer about potentially strategy or any other thing could be raised on the record, should have been raised on the record, would be on the record, for purposes of appeal?
for purposes of appeal, there could be an argument raised concerning ineffectiveness where it appears from the record that concession actually did prejudice the client, because that is something that is a necessary component of ineffective assistance. It's not just objectively deficient performance on behalf of trial counsel, but that objectively deficient performance, but for that objectively deficient performance, the result would have been different. And in this case, there was so much overwhelming evidence concerning Mr. Meyerson's guilt, at least as, I'm going to say, at least as to the felonious assault and the child endangering, that even not considering the evidence concerning the rape, it might have been a sound trial strategy on the part of the trial counsel to concede that point in order to try to focus the argument on the rape and to try to avoid the life sentence that Mr. Meyerson is now serving. And I would also direct the court to take a look at the specific averment that Mr. Meyerson makes in his affidavit, because counsel is saying that that was sufficient to raise this, to merit a full hearing at the trial court on this issue. I direct the court to look at paragraph 55 of the affidavit. That is not specifically an averment that says, by the time we came to to closing argument in this case, I told my counsel not to concede. That's not the case. What he avers is that he told his attorney he wanted to plead not guilty, and that he was not guilty of the crimes, and he was denying responsibility for the crimes and asked his attorney to defend him on that. But there is nothing to indicate that by the time closing argument came up, and after hearing all of the evidence that came in during the trial, there was any kind of discussion of that nature where Mr. Meyerson said, I don't want you to concede, and the attorney did it anyway.
So you would agree that evidence outside the record?
That is outside the record, but again, there still has to be a showing, even at the motion stage, to merit a hearing, that was prejudicial to the client, and Mr. Meyerson cannot do that. The evidence in this case was just overwhelming for guilt for all of his offenses. So, whether or not his attorney conceded guilt on 2 of them is actually immaterial, given the full evidence that came into this case. And that's important to remember. It's not just the deficient performance. It's got to be prejudicial. And that has to be evident, not speculative, but it has to be evident from the face of the post-conviction relief petition itself, along with the materials that are attached to it. So and I also want to reiterate to the court, this has to be reviewed by this court for an abuse of discretion. That's not mere error. That is something that is unreasonable, unconscionable, or arbitrary. It's got to be a decision that is not supported by a sound reason, any kind of sound reasoning process. And that's why it would be unreasonable, arbitrary, or unconscionable. And so long as there is a sound reasoning process, which this trial court displayed in its ruling, then this court cannot merely disagree with the trial court and reverse.
Did the trial court make any credibility decisions in its decision to deny the post-conviction relief claim?
There were a few. The trial court, for instance, regarding the affidavit of Mr. Meyerson's mother, discounted that as being, for instance, it would have been, her word would have been hearsay. Also, I believe the trial court discussed whether that was essentially a self-serving affidavit, basically
How can you
serving.
make that determination of self-serving without hearing the person testify and making a credibility decision? I think some of the stuff, as I recall, may have been hearsay, and I don't disagree with that. Some of that was, I observed X, Y, and Z. I appreciate you can decide, well, that's mom, I'm not going to necessarily give weight to that, but don't you at least have to hear her first, decide if you should give credibility to what she's saying?
Well, considering that the court also has to think about these motions in terms of everything that was already in the trial record, and all the evidence that was in the trial record contradict any kind of testimony by the mother about this child's condition prior to him showing up at the hospital with a brain bleed. So, the medical evidence contradicts her, and that, of course, was something that the trial court could consider. So,
This gets into the province of the jury. That's why we have juries, so judges don't make these decisions. If this was important, this could have gone to the jury, they may have decided differently. And the judges ultimately, without even having a hearing, making credibility decisions on these kind of questions, and the question about what the doctor may or may not have testified, and deciding without a hearing whether this person was or was not a qualified expert. Is that an abuse of discretion? I appreciate we haven't seen abuse, and it's not just the average case, but when you see some form of abuse, would that be an abuse by the trial court?
actually, no, because the credibility determinations of affidavits is something that is for the trial court to determine in a post-conviction relief petition. So it does get to make credibility determination. So that per se is not an abuse of discretion.
It does get to make that decision even on the affidavits?
Yes, it does. There's long-standing case law concerning that, not just in the context of post-conviction motions, but also in the context of motions, for instance, for a new trial, where, for instance, you might have somebody that, say, a witness might be recanting, The trial court does get to weigh in on and determine the credibility of those affidavits. So this is actually within the trial court's purview. So that in and of itself does not constitute an abuse of discretion. Similarly, regarding Dr. Fadul, I want to address that very quickly. You do need a pediatric neurologist to determine or to opine as to the cause of traumatic, brain injury and brain bleeding in a child like this. Dr. Fadul's CV is the basis for, it's the basis for determining whether he was qualified to testify or to offer an opinion as to this. And based on his CV, he is not. His experience has been more geared in recent years to the business of operating a hospital, not in diagnosing children with traumatic brain injuries and treating them, versus the opinions that came in at trial of people who were actually in the business of treating children with traumatic brain injuries. So with respect, the trial court could make that determination that that was not that would not have actually assisted, that it would have been excluded, and therefore it's not a sufficient basis to have a hearing. Regarding Dr. Rose, that testimony or that affidavit, the trial court found could have actually hurt Mr. Meyerson, because he opined that the injury the child suffered to his anus was not the result of a fall, and was more likely the result of something actually being at least attempted to be inserted into his anus. So that's not helpful to Mr. Meyerson in this case. So it would have actually harmed his case. So
My understanding too is at the trial level, the attorney asked for funding for an expert and actually received funding for an expert. I'm not sure if that expert actually testified. Did the expert actually testify during trial? For the defendant?
No, the defendant actually hired the expert, had the money, hired the expert, obtained an opinion, and never had the person testify. And so that expert's testimony and report is not in the record. So we don't know what that expert's opinion would have been, favorable or unfavorable. One may imagine, however, in reality, that if it had been favorable, the expert would have testified. But regarding the rest of Mr. Meyerson's petition, again, I'm just going to very briefly touch on what this court has already decided.
Let me have one question before we move on from the doctor.
Sure.
Did the trial court, I'm trying to scan through here, did the trial court specifically find that the first doctor, the doctor that the pediatric question was brain injury, did the trial court actually find that the doctor was not qualified? Or the doctor, as I recall, or the court just dealt with that as a bunch of trial tactics and never made a specific finding that this doctor was not qualified to testify in this case, based upon their CV. My recollection, scanning, my recollection is she didn't make that finding at the trial court level. The judge simply said, that's the trial tactic. And to call that for not to the trial tactic and made no specific finding.
I don't recall either,
Fair.
Your Honor,
That's
as to whether she made that specific finding that he was unqualified. Obviously, it was our argument on behalf of the state that he is unqualified.
Well, you don't, and that's fine. If you don't recall if the trial court made that finding, thank you.
No.
You may proceed.
That's perfectly fine, Your Honor. But again, I just wanted to remind the court of what this court has already decided concerning Mr. Meyerson's post-conviction claims. It's already decided that the notes of Dr. Keck McNulty, who was the expert, the treating person who had passed away prior to trial, this court's already found that the notes were admissible, that they did not offend the confrontation clause, that the victim's statements in them were not excludable under Evidence Rule 807, whether or not Mr. Meyerson could have had a suppression motion. That was evident by from what was in the record and could have been addressed by this court, because the officer's statements as to how he interviewed or how he spoke to Mr. Meyerson and under what circumstances he spoke to Mr. Meyerson is in the record. Concerning evidence rule 805, again, more Keck-McNulty notes, that could have been addressed by this court, because that question could have been raised based on what was in the record. Similarly, any other objection to that doctor's notes as hearsay or unauthenticated, regarding unauthentication, that's actually contradicted by the record, because there was the authentication notations affixed to those notes. Whether counsel should have raised a question as to which means by which the felonious assault occurred, that too was something that could have been raised based on the evidence that was in the record. And but what is meritless flatly is any kind of argument that this attorney was ineffective for not raising a suppression motion based on Miranda. Mr. Meyerson simply was not in custody at the hospital, and contrary to his averments that he felt like he had to go to the police station willingly, or he was going to be taken there unwillingly, shows that he actually willingly took himself to the police station. So such a suppression motion would have been futile, and no attorney is required to raise a motion that would have been futile or frivolous in order to be considered not to have rendered ineffective assistance. Similarly, any kind of failure to object to the jury instructions in this case, those jury instructions came out of OJI, which are essentially promulgated by the judicial conference so that they are correct statements of law that the judges can use. So that too would have been a futile objection. And finally, again, the authentication of Dr. Keck-McNulty's notes, because of the authentication affidavit affixed to them, that would have actually been frivolous. So since I have but 12 seconds left, the state would respectfully ask this court to affirm the trial court's judgment unless there are any further questions from the court.
Thank you, counsel.
Thank you.
Thank you.
Excuse me just a second. Thank you. Very briefly, on the McCoy v. Louisiana issue, my colleague responds with the same arguments offered in her brief, and she didn't say anywhere where my client's express objection would have been noted in the record. That proves the point, right? It could not be barred by res judicata because that critical piece was outside of the record. Now, my colleague talks about prejudice. The idea that a concession of guilt does not prejudice the defendant is wildly inappropriate. In McCoy v. Louisiana itself, certainly that attorney thought that the case was won in terms of, by prosecution rather, by the evidence in that case. And so in their learned experience decided to concede guilt to try to avoid the death penalty. And McCoy, Louisiana is the absolute binding authority that says that cannot be the case. So I think that issue is the strongest issue. I don't think it's
on the issue she raised regarding the affidavit your client filed, it wasn't a clear requirement not to concede, if you will. What would you say about the affidavit your client filed?
When you plead not guilty, you ask a defense attorney to defend you in that case, and you say, I did not do these things. In order to concede guilt, a counsel has to advise you of that and has to get either silence or an agreement, right? The idea that there is, that the affidavit is insufficient, I mean, I don't know exactly what else the court would want. He pled not guilty, he said I want you to defend me against these cases. And the prejudice issue, I also want to speak to, that when you concede that someone committed felonious assault against a child, it does open the much more broad possibility that that person is a sadistic monster. And so it makes it more likely that they might be found guilty of the, I think, less supported or the, rather, the more serious offense in the case. And so I do think that the prejudice is on that part as well. It can't be
I
kind of
can ask
washed
you
away.
on the,
Yes, Jim.
moving from that issue, on the question of res judicata.
Yes.
Certainly we have the questions you would say of what your client did or did not concede regarding what you just talked
Yes.
about. We have the uncalled witness questions on there, what witnesses were called, and that would seem to me to be evidence outside the record.
Yes.
Is there anything else you think is evidence outside the record that was brought by your motions that would not be subject to res judicata?
We would note, Your Honor, that res judicata is not a jurisdictional question, it is a jurisprudential question, and it must be set aside in order to avoid miscarriages of justice. Here, Your Honor, we have jury instruction issues that were not raised on, at the trial counsel. They were ineffective for doing that. Res judicata should not bar this court from considering that issue, and it doesn't. The court can't set that aside. And so, Your Honor, those issues, I believe, are the strongest and the cleanest, as you stated, and I think they deserve to get a hearing in the trial court. The idea that a judge can make a determination on credibility based on the affidavit, I mean, certainly, if there is evidence in the record that directly contradicts it, you may be able to get there. But there is no evidence that contradicts the record
Do
here.
you recall if the judge made a specific finding that your expert was not qualified?
I absolutely recall, and she absolutely did not. So with that, Your Honor, I would just say, we believe that this case deserves a hearing in the trial court. That is all we're asking for. We need to have it reversed on at least the McCoy v. Louisiana issue. I think as well on the experts issue, because there was a failure to investigate that entire class of claim. The entire story that my client says happened to cause the head injury was not investigated. Not his mother not called, and neither the expert. We ask you to reverse. Thank you.
Thank you, counsel. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which the clerk will mail on the day it's released. You can also find it on the Ohio Supreme Court website. Thank you.